Thank you. I've given you, and I hope everyone got a chance to look at the what I'm proposing that this committee adopt as a resolution, which before even considering any vote would be a medical marijuana patient bill of rights. I think the need for this is can't be overstated, despite the fact, and you've heard already testimony, that there's very specific enumerated rights in the Michigan Medical Marijuana Act. They've been eradicated in the courts. And when you look at the Michigan Medical Marijuana Act, it needs to be looked at from the position in the courts. The reason a person goes and gets their card is to protect them against arrest or to use it in court to defend themselves. I know that the bills were presented from Representative Horn, as he stated, from a 30,000 feet looking down, and I can appreciate that. And even from that view, I think it's overwhelmingly clear that the law hasn't been implemented. The cards are, for 4 years, been 7 months behind. There's no new conditions on the registry. The veterans who, it's well documented, receive tremendous benefits in their acclimation after seeing battle, have greater success with PTSD when they are using cannabis. And now we are debating the privacy of the patients, which is another right that's very clearly enumerated in the statute as well as in the administrative rules. But the real way that I believe that this committee should be looking at the issues is through the eyes of the community who these laws affect the most. It's easy to make judgments in the comfortable chambers that we're here, but unless you see and hear what is actually happening to the medical marijuana community, they're being devastated in court. What this community really needs is a hero. We need a legislature to step up and utilize its authority under Article 2, Section 9 to implement the initiative. It's not happening. Brother Stecker gave a presentation, albeit I disagree with minor analysis of some of the things. It was very well thought out, and it pointed out the specific rights in the Michigan Medical Marijuana Act that are supposed to be granted to the patients. Did you hear what the statistics were in the courts? Patients and caregivers 0, law enforcement and prosecutors 15 wins. 0 wins to 15. What should be noted is that of those 9 published cases, the trial courts ruled in favor of the patients and caregivers. The discrepancy in that kind of legal reasoning should tell you that the legislature needs to act and act powerfully to make certain that these rights are not political ping pong in the courts. And my position, our position, is we're hoping that you will look to the public health code as a manner to ensure that these rights are afforded to patients and caregivers. What we hear in court is that the Michigan Medical Marijuana merely is a exemption to protections, but it did not override the public health code. Well, that has been the justification to deny people the right to present a defense in court. My last four clients have been 65-year-old couples who've been married 30 years, and I'm in court with the prosecutors discussing whether their doors were locked to their basement. It's at that level of ridiculousness. There's a new emergence in law enforcement of being specialists in arresting for the loopholes of the protections of the Michigan Medical Marijuana Act. I'm saying this from my perception of people that are getting thrown into the court system that never thought that they would find themselves there, and at an older age with debilitating conditions are finding themselves with the worst place they could be in the criminal justice system. There are many, many, many stories, and I don't want to go past my time, of course, but the question is, you have 80 years of prohibition, essentially, of marijuana. And then 63% of the voters passed this law and still support it. It's at 70% right now. How does one change the fabric of our society in viewing marijuana, just generally, or medical marijuana? Nothing has happened. There's been no advancement of any education, training for law enforcement. Some of these very vital issues of usable material, uninterrupted continuous supply have not even ever been addressed by law enforcement. And there's never been a real attempt, I would say, to understand the needs of the medical marijuana community. You know, some of these bills, and the way the law has been destroyed in the Court of Appeals, doesn't even recognize the simplest concept of what this law was intended for, which was allow people to get safe access and not have to worry about arrest. If you take the patient that we would all agree to, dying of cancer, came out of chemotherapy, and is at home throwing up in a bucket, and they want to get certified and try to use cannabis as a medical treatment, where do they go to get started? The law would call that a crime in that acquisition right now. If they do take that risk and get some clone or a seed and start growing it, it's going to take 4 months. Where are they supposed to go now? Are you supposed to tell the puking person in the toilet, just wait, my plants are almost going to grow, they're almost going to be here? And then you're assuming that that person who's acting as the caregiver actually knows how to grow cannabis and that they're going to be successful after 4 months. And if they're not, the throwing up sick person has to wait even longer, and they don't have access, safe access. And the law as it's written right now would deny that fact, that patient who's sick to be able to acquire cannabis. I'm asking this committee to look at this from a place of not happening like it's supposed to be happening and acknowledge that the public health code is what's dominating here, and unless we look to the public health code and address the prohibitions there or acknowledge medical use as a legitimate way that people use cannabis, then we're not going to get anywhere. My final comment was I wanted to just point out, as you may or may not know, in the finding and declaration section of the Michigan Medical Marijuana Act, it states, the people of the state of Michigan find and declare that modern medical research, including as found by the National Academy of Science Institute of Medicine in March 1999 report, has discovered beneficial uses of marijuana in treating or alleviating the pain, nausea, or other symptoms associated with a variety of debilitating medical conditions. The citizens of Michigan declared by virtue of vote that cannabis is no longer a Schedule I substance. Yet every mention of marijuana in the public health code has done so on the premise that it is a Schedule I substance. You as a legislator need to be aware of this fact and how the discrepancies that I'm describing is affecting the protections of patients out in the world where they live. Changes or amendments to honestly protect the medical marijuana community needs to take place in the public health code so that it can be synchronized with the intent of the voters. So, in conclusion, I'd ask you to not amend the law. I think and just to follow up with Brother Counsel from CDAM on the issue of the opening up the registry, and Chairman, I believe
Ms. Komorn,
we over? Okay.
Yeah,
well, thank you for
I still want to get one more group in, so I want to leave time for questions for the two of you. We have Representative Damrow.
Thank you, Mr. Chair. I think there's some misunderstanding, especially related to your statements. Making the statement that we're here to repeal this law is not what's taking place. At least that's how I understand it. What we're looking to do is to clarify and to stop the situations and addressing these situations that you have both addressed, for the most part. But you know, the testimony though that I'm looking for, and at least I'm just speaking for myself, is the recommendations to not the facts and the figures and the numbers that have led to this situation. You know, we're doing a lot of work in a very brief amount of time. If you took a look at what it would take to have something changed at the federal government to get a drug approved, 5, 10, or 15 years to make just to the point where you can get it to the public. This committee and the work groups have worked on something in just a very short period relationship to a law that was approved by the state voters to try to stop what's been going on is people being arrested and being denied what the voters had thought they were going to get. So I'm sorry, but I'm looking more for recommendations of how to make it better and not the statistics which already I think.
But the recommendation, as I said, I would suggest instead of amending the act, it nullifies it. It takes away its strength. There's a amendment that's added for right to a jury trial. It already exists in the law. It should be in the law, the right to present a defense. You don't need to amend the act. You need to go into the public health code and declare that in marijuana cases, there is a thing which is known as medical use, and it should be recognized in the statute. The doctor-patient relationship issue, this bill, Lara just spoke on this. No one has mentioned this, and I don't know if the committee is aware of it. But the Licensing and Regulations Affairs Committee that manages the program, the medical marijuana program, and also the licensing of physicians, came out with a memorandum. The doctors suggested to the doctors, if you're going to certify patients, this is what we recommend. And they will be the ones that judge the doctors if they don't follow it or they hear of things. This is a much better approach. We don't want judges making medical decisions, like we don't want doctors making legal decisions. The administrative agency that manages has already spoken. That bill about changing the doctor-patient relationship is really irrelevant. Let the doctors handle it.